I'm happy that you have painted that part of your arrest and your stay in custody. Now, the charges. In East London, you appear on 2 charges: the malicious damage to property and the extortion. Do you know what happened to the 3rd charge?
No, I don't know.
Of course, you may not know because you are a subject of these charges. Ma'am, tell this court your reasons for wanting to be released out on bail.
The first reason, in fact, there are many reasons, but those charges I will prove beyond reasonable
You want to say doubt?
yes, that those charges will be are not valid. I don't know how to say in legal terms, but these are frivolous charges, and I will prove beyond reasonable doubt that they are frivolous, and therefore I really cannot stay in court for the charges that I am going to prove, and I cannot stay in prison for the charges that I am going to prove beyond reasonable doubt. And in fact, had the NPA investigated, they would have got the eviction order that says demolish. And had the NPA investigated the extortion, they would have understood that there was an agreement with my tenants that they are going to pay, and in fact they did pay. And I have got the witnesses in respect of them agreeing to pay. So basically, those charges are so frivolous for me. That is number one, my reason for wanting the bail. The other.
Wait, ma'am, just there. I'm happy that we're stretching it, but it's okay. I'm happy with it. You said on the charges of malicious injury to property, you have a court order that so states that you must remove, demolish and remove structures in your property.
That's what it says.
And this property is yours?
This property is ours, yes.
Oh, thank you. On the charges of extortion.
So you're saying the court order was in respect of removal?
The malicious,
Demolition of the structure?
yes, demolition and removal of the structures.
Yes.
Thank you, Worship. At this juncture, Your Worship, it is my application to hand in the copy of the court order in respect of what my client, Your Worship, is talking about. Any objection? Thank you, Worship.
No objection.
May I be granted leave to hand it in, Your Worship? Thank you. Okay.
In addition to the court order that you have, Your Worship, this very same court I don't mean this one, but the harassment court. We went to the harassment court. This harassment court ruled that the illegal occupiers must pay 70,000 per month. That was the ruling. Now, they must pay in the property that they are occupying, because in that property we are paying rates, and then the rates would be loaded with illegal connections, electricity connections and water connections. So when we talked with the community, they understood, because I got them to understand that this is what I am paying for in respect of this farm. That is excluding the amount of the money that we paid to apply for the eviction order. And when few of them who acted with like as if they are all of them, which was not all of them, they went to court, and that case was heard, and the magistrate ruled that they pay 70,000. Now, I am here to see how the other court would say this is extortion, whereas the same court said the people must pay. So I really do not know how the extortion would be proved.
What happened to the harassment case?
The harassment court case was dismissed. I think that was in February. The harassment court was dismissed.
Thank you. Your Worship, with me, Your Worship, I have a copy of what may be the court's ruling on the matter in which my client has testified about. Thank you, Worship. I crave for leave, Your Worship, to submit say.
Copy of the harassment orders and mark exhibit B.
And now there's an issue about extortion. And I understand it is a buzzword now in South Africa. And it has seen the loss of life of people who are alleged to be extortionists, and I believe that's a serious one. How do you feel about the charges of you being called an extortionist now? You are now an extortion.
Of course, this whole matter has got an effect of damaging my good reputation. And to be called an extortionist at this day and age, it also poses a risk on my life, where people would believe that I am an extortionist, and I may even be killed because of being labeled as an extortionist.
If I see a perfect picture of what you have tried to paint before this court, is that the people who are occupying your place, your land, are the ones now over an agreement that you had with them in a meeting to say that they need to pay rent, are the ones that are calling you an extortionist, or you are now charged for an extortion. Is that what you are telling this court?
Yes.
Now, tell this court, how do you intend to plead on these charges in a court where this matter will be arraigned?
I will definitely plead not guilty
To one charge or both of them?
to both of them.
And I do want to believe that you have at least tried to show how, without hiding any of your ace cards on your chest.
Yes.
Thank you. Your state of health, ma'am, how are you?
Of course, due to my age, I am not that well. I have sometimes a short breath, especially in places where people are smoking. So, and also when I am under pressure, I do have the short breath. And yes, of course, like women issues like isigulo nje sabafazi.
Any experience in the period of your incarceration?
Yes, I did experience the short breath. I did experience some bit of dizziness. Yes.
And how has that affected you right now?
Of course, I am emotionally drained, and health-wise, of course, prison is not a good place to be at, especially for a law-abiding citizen like me.
A requirement is needed on a bail where interest of justice needed to be shown before any court. I will now refer you to the provisions of Section 64A to E. I will enumerate to you and ask if you will abide or not. Should you then be released out on bail, will you endanger the safety of the public or any particular person, or commit another offense while out on bail?
At the moment, as I said, I am out on bail with a Palm Ridge Magistrates Court, and that bail was awarded last year, and I haven't breached any conditions of that bail. And as I said, I am a law-abiding citizen. If given the bail, I will be here again at the time that I am required to be here.
Will you attempt to evade your trial?
I just want to get your specific answer. Are you going to endanger the safety of the public or any other person?
No, I will not be able to do so. And in fact, Your Worship, I do not even have capacity to do that.
Thank you, Your Worship. That is satisfying. Will you attempt to evade your trial?
No, definitely not.
If you are then released on bail, will you attempt to influence or intimidate the witnesses in this matter, or conceal or even destroy any evidence?
So Mary, on the question of whether or not she's going to be raised with the child, I'm not sure whether you're still going to mention whether or not she's in possession of the passport.
Yes, Your Worship, I was going there.
No.
Maybe that the court has now given, let me just ask that. Do you have any passport, ma'am?
I have a passport that is kept by NPA.
Already in the hands of the state? If you then released Mem out on bail, will you attempt to influence or intimidate the witnesses, conceal or destroy any evidence to be used by the state? I know you may not know the evidence to be used.
I am not. I will not do that. No.
Will you undermine or jeopardize the objectives of the justice system or bail conditions?
No, definitely not.
Will you disturb the public peace, order, security, or undermine it?
No.
I heard you said you're unemployed.
Yes.
If bail can be set, the court be inclined to grant bail in this matter, how much can you afford?
2,000 rand.
And who will be paying?
My husband.
All right. I see you looking, court. Is he here?
Is here. Yes.
All right. Do you think is there anything that I may have left out, which you may wanted me to say, to ask you?
No, I think you have covered everything.
Or maybe before that, as per instruction earlier on, I heard you mentioned that there are people who are even ready or who may even come to witness that indeed there was an agreement made amongst the members or the community members in the family, which you said it has been occupied.
Yes, they are also here.
Are they also here in court?
Yes.
You said that they are ready to testify in your favor.
They are ready to testify to my bail, and they are also ready to confirm that there was an agreement, because that agreement was decided in a meeting, properly constituted meeting.
Your Worship, with this witness, I am done. Thank you.
Yes, Worship. State just has a few questions, Worship. Mrs. Kwinana, you mentioned that you have no assets of value, is that correct?
Yes, I have no assets of value.
And are you familiar with a company called Slipknot Investments 74 Pty Ltd?
Yes,
Are you Slipknot Investments 74 Pty Ltd, Worship?
yes, I am.
Are you affiliated with that company in any way?
I don't know what you mean by affiliation, but that is a family business company. I am the secretary of that company.
Are you a director of the company? Just the secretary?
I'm not a director, I'm the secretary of the company.
Do you have shares in the company?
No, I don't have shares.
You do not. Okay. Secondly, you mentioned that you have a pending case of failure to disclose to the PwC your affiliation with them. Is that correct?
Yes.
However, ma'am, the charge which we are aware of is that of fraud. Can you please explain the inconsistency between that?
Yes. In fact, I am happy that you cannot link that failure to disclose and fraud. And that is exactly the reason why we have applied for the objection in court, which will be held in April, because the failure to disclose the previous interest, in which case we tendered with PwC in one other company, and that company, we did not even get that tender, which was which was the past relationship. That is what they said, it's fraud. And hence we are laying an objection to the charge sheet being fraud, because failure to disclose does not meet the elements of a fraud, especially that I did not benefit, or I did not benefit from their involvement at SAA, and then now it is called fraud. Hence we have laid an objection which will be held on the 12th of April.
And you mentioned that on the day you were arrested, which was the 17th of March, where were you on that day?
I was at my house in Blue Valley.
With whom were you there with?
I was with my lawyer and my husband.
Okay. And you mentioned that the police, you didn't know there were police at the time when they arrived, is that correct? What vehicles were they traveling in? Were they marked vehicles, unmarked vehicles?
I cannot confirm the vehicles that they were driving because of the way they did things. However, the security gate can confirm what vehicles they were driving.
Did you see the vehicles at any point in time?
Yes, because I was put in the vehicle, so I saw the vehicles. But the way I was taken and snatched, I cannot confirm what type of vehicles they are, and I even cannot confirm how many they are, because without clearly, what are you going to do when you are snatched?
May you please just use one language, ma'am, for the record. You're going to confuse it. Thank you. The reason I ask this question is it's a simple question, ma'am. Did you see the vehicles when you were being taken? Were there any police brandings on them?
I can't remember. I don't know.
So you couldn't see the SAP as the big bright letters on the car? You couldn't at that point in time? Okay. Were the police officers, the alleged police officers, were they wearing uniform on the day, or were they dressed in casual clothes?
I don't know, but they were wearing, most of them were wearing navy clothes with brown or navy balaclavas. So that's what I can remember.
And none of them had any police insignia or any indication that they were the police?
I can't remember.
Do you remember the clothing of the one who must have attended to you?
The one who said he is Gevan or something, which I later found out in Sentin that he is Javan. I think Javan, yes. I think he was wearing brown clothes.
Brown clothes.
Mm.
And you mentioned that you stay in an estate.
Yes.
Prior to the police having entered, they would have to have passed the gate, is that correct?
Yes.
What did they tell the people at the gate? Who were they?
I was not there. I was not with them when they got in. So I don't know what did they tell the security.
But prior to them entering the estate, would they not have to be granted permission by the person whom they're going to see?
They did not. They did not ask for the gate code from me.
What I'm asking, ma'am, is that do you have security at the gate?
Yes.
So your security never informed you that there were people who are asking to be given access to your compound?
No, they never informed me, but they were there in front of my house, the security police.
Okay. So your answer is basically that the police were just given access, you were never informed, they just arrived in front of your house. Is that what you say?
I don't know if they were not given access at the gate. I am not the security guard of Blue Valley Golf Estate, so I don't know how did they enter. I cannot say they were not given access or they were given access. I really do not know.
And you mentioned that you sustained bruising
Yes,
during the time when you were being arrested, is that correct?
yes,
And you also mentioned in the same breath that you resisted being taken away.
yes, because I did not know that I would be taken away. I knew that I was going to give the statement. I did not know, and I was asking, why am I being taken away? Because the understanding is that I was going to give a statement. So that's why I resisted. That's number one. Number two, those people were so scary. Like if a person is wearing a paraglove, you can't even identify who the person is. And in fact, I really thought that I was being kidnapped.
And let's just go back a little bit. You mentioned that the person whom had called you from the police, did he introduce himself as a police officer to you?
Le Dimo did not introduce himself as a police. Hence, that was previous, like when we were arranging if they are going to come. He did not introduce himself as a police. When he first called from the farm, I said to the security guard, let him call using his phone. And his phone, my true caller, indicated that it is Sergeant Ledimo. That is how I got to know that it's Sergeant Ledimo. Then I said I can only meet with him if I meet with Fleet Street police station. Any person from police station, but the person that I mentioned is Kowi, because at some stage I went to make a statement with Kowi. Kowi called and said, there is a case against you. When can you present yourself to the police station to make a statement? I did go to make a statement. I said to Sergeant Ledimo, I do not know you. Let me, please make an arrangement to see me in the presence of Warrant Officer Kowi, because Warrant Officer Kowi, I went to his office, and therefore I can confirm that he is a policeman.
When did the communication between you and Warrant Officer Kowi take place?
That was maybe, I would say, maybe a week or 2 weeks before the 17th.
A week or two before the 17th.
Mm.
And you mentioned that you had made a statement.
No, I did not make a statement.
Okay. And on the day when the police entered your compound, was Mr. Modimo there?
I don't know. There were many of them. And at the time, I did not even know who he is. So I would not say he was there or he was not there. Because there were many, maybe about 15 or 16 of them. Maybe one of them was him, or maybe he was not there. I really cannot say he was there or he was not there.
Okay. Let us move along, ma'am, to the reasons for you wanting bail. And you said that your first reason was that the charges aren't valid, as well as the fact that they are frivolous. Is that correct?
Yes.
Okay. And you mentioned that you had gotten an eviction order to demolish the properties which are at the Epongwene location in 2020. Is that correct?
Yes.
Did you ever appear in front of the High Court of South Africa here in the East London Circuit Court?
East London?
Circuit Court.
East London Court? Which court?
The East London Circuit Court, the High Court here in East London. Have you ever appeared before it?
I've appeared many times.
Many times. And are you also aware that there was an interdict which was granted against you to not demolish the houses on your land?
I am aware of that interdict by the Honorable Hati. However, that interdict did not nullify the Judge Malusi interdict, the 2020 interdict?
It does, ma'am.
Then that's
It does, ma'am, due to the fact that your application had happened in 2020 and you are subsequently interdicted in 2024, meaning that any procedure or any rights that you were given under the previous order are interdicted in 2024.
then
Did they not explain that to you?
that is a subject of different interpretations.
Will you-
I
will you-
still maintain that Judge Malusi 2020 order was not nullified by the interim interdict. And another thing, that interim interdict, it is still in process. We are going to court on 21 of July.
Were you legally represented in any of your application as well as this application by the residents?
No, I don't have money to be legally represented. The reason being that there was in my land where I was paying rates, as I said, where they are using illegal electricity, illegal water, and me paying rates. So I did not have the legal representation.
Was it not explained to you that upon granting this interim interdict, you are not allowed to further demolish any properties on your land?
That is a matter for discussion, and that is a matter for the different interpretations.
I do believe you can answer this question, and it's a simple yes or no. Was it explained that you must not proceed with the demolition of the houses?
No, it did not say I must not proceed with the demolition. It did not say.
At this juncture, Your Worship, the state is giving the defense a chance to look at the interdict.
Can I also have a copy of Hartley's judgment? I just want to read this paragraph that you say. It said I must not continue with demolitions.
I believe it's point 2.1, and if possible, could you just read it into the record?
I still confirm that this is not saying I must not proceed with demolition.
May you read it
Let
into
me
the record?
read it for you, Your Worship. The first one is saying, declaring that the removal of the applicants from their home at portion 11 farm 925 by the first, second, and third respondents constitute unlawful eviction. It does not, in this paragraph, there is nothing that says I must stop demolition.
I
And then
understand
the
that.
second one, directing the first, second, and third respondent forthwith unlock access gates of portion 11 of farm 925 and to allow applicants to return to their homes on the land. There is no stopping of demolition on number 2. Interdicting and restraining first, second, and third respondents from threatening, interfering with, and subjecting the applicants to acts of intimidation and unlawful eviction. There is nothing that says I must stop demolition. The second last one, interdicting and restraining the first, second, and third respondent from advertising and renting the applicant structures out while the applicants are still occupying them, or without the consent of the applicants. The last one. First and second respondents are ordered to pay the cost of this application on the scale as between party and jointly and severally. I mean, really, I cannot see any stopping of demolition in these four sentences.
Let us go back to 2.1 now, where it says, declaring that the removal of the applicants from their homes at portion 11 of Form 925 by the first, second, and third respondents constitutes unlawful eviction. Would you agree with me, ma'am, that if you were to demolish someone's house, they would have nowhere to stay?
Mr. Ndolo, proceeding to pose questions now on this order.
Indulgence, Your Worship, apologies. May, at this point in time,
Yes. It's not before me.
Court, please, Your Worship. With leave of the court, Your Worship, may the state submit.
Any objection?
None, Your Worship.
Set court order, the resolutions are taken on the mark of C.
Yes. Would you agree with me, ma'am, that if you demolish someone's home, they have nowhere to stay?
Correct?
If you demolish someone's home, they would have nowhere to stay.
We are here talking about demolition. You said that Judge Hartley's order is saying I must not demolish, and I have proved to you beyond reasonable doubt that the 5 rule misses that are there do not say I must not demolish.
I understand, ma'am, but may you please answer this one question. Would you agree with me that if you were to demolish someone's home, they would have nowhere to stay?
Your Worship,
They will have somewhere to stay because before they stayed there, where were they staying before? And in fact, between 2020 and 2024, they would have got alternative accommodation. So for you to say they would have nowhere to stay is not correct.
So you agree with me that
They would have somewhere to stay.
Your Worship, I stand to object, Your Worship, to the line of question. This court is not here. It's not sitting here to listen to the interpretation of the orders of the court. What my client has told this court is that this interim order that is before court today has not in any way set aside the decision of the previous court, which says my client can demolish and remove the structures that are in the piece of land. This is still, Your Worship, an interim order, and a return date to enforce its finality has not been attended to. Thank you, Your Worship.
Where are you with the question?
yes, Your Worship, the state is just going to the fact that by demolishing the homes of the residents, it is quite clear that they will have to leave the area and have nowhere to stay, Your Worship, which is in line with 2.1, the removal of the applicants at their homes. Because if you destroy their house, they have nowhere to go. They have to leave.
I would apply as section 64 now is concerned.
This court, please, Your
How
Worship.
do you relate that to what will happen?
I will get there, Your Worship.
Your Worship, indulgence, my client, Your Worship, wishes to attend to the call of nature. You may ask for
Time now is almost 25 to 12.
25 to 12. Yes, Your Worship. 5 to 10.
5 minutes.
5 minutes, Your Worship. Thank you.
What is adjourned until you have the short?
Are you sure?
qualification of a chartered accountant. Ever since the Zondo Commission, she has faced a number of allegations and bad publicity. That has made her a bit firmer than she used to be. So she knows the need to cooperate with the police. That's why I am saying, when she had a matter, this matter that is a pending matter where there was confusion about she's saying is failure to disclose a conflict of interest. I explained to her and I accompanied her to go visit the offices of the Hawks. She was on good terms with them because I explained the procedure. That's why I had phoned Mr. Bangani to explain the procedure to her here and take her to those police. And there, everything was so cordial, Your Worships, in so much that, yes, when we wanted to buy drinks for all of us, the officers refused because they said they would be compromised. But we all went to the police station, and from there we went to the regional prosecutor, Mr. Mhlongo. Bail was arranged. It was not even opposed because there was cordiality. So she was not cheeky, she was not anything. She just had an attorney to keep saying to her, this is the process, this is how it works, and she was satisfied with that.
Thank you. You may proceed at a point where I interjected you.
Thank you, colleague. And then it became then clear that there was no docket. That is what Mr. Bangani came back to me to say. There is actually no docket. Because of the difficulties, we asked a local lady here who is a relative, Yakhe Kwinana, to please go track down this investigating officer who is Mr. Ledimo and the prosecutor. Yakhe Kwinana waited outside, and then I spoke to that Mr. Ledimo who was on the phone. And Mr. Ledimo now changed tack completely. He said, first, there is no docket. The docket was left in Johannesburg. It's going to come by an afternoon flight. So, and then I knew that if there's no docket, then the matter will not go to the prosecutors. I then phoned Mr. Yakhe Kwinana had phoned me. He was the officer who had accompanied the applicant to come here to the Eastern Cape. I said, Mr. Yakhe Kwinana, where is the docket? Mr. Yakhe Kwinana hesitated once and said, the docket is here in my bag. Then I said, but Mr. Yakhe Kwinana, I had told you that the investigating officer is Mr. Ledimo, and I had explained to you that the client is supposed to appear today. Why don't you take the docket to the investigating officer? That is Mr. Ledimo. Mr. Yakhe Kwinana said he is going to do that. After about 3 hours, I discovered that Mr. Yakhe Kwinana had not done that. Mr. Yakhe Kwinana did not say anything negative about the client, about the applicant. But when I went back to Mr. Ledimo to say, Mr. Ledimo, I understand now that we've got the docket, Mr. Ledimo now became angry with me. He said, you know what? You are confusing me. I'm busy with one court, you're making me to be busy with another matter that is not here. Then it became clear that the relationships had broken down. So the client then would not be brought into court as we had been promised. The client would be brought here in court. So that is how it happened then, insofar as the arrest and the non-cooperation, which your worships, I'm honest to say, we just did not get any cooperation from the investigating officers, except the repetition that this applicant is a stubborn person and they're going to show her because they are provincial police.
Now, let's move. Thank you for such a narrative. Let's go to the issue. You seem to have knowledge about the issue of the orders that were granted.
Yes. Your worships, it is true that this applicant does not have personal assets per se, but her family, via a number of trusts, I think there are about 3 family trusts, and via this property development company, Slipknot, specifically Slipknot Investment, owes this property that is here in East London, which in a way is the foundation of these charges. When this client did the eviction, the attorney who was instructed was Mr. Bangani, and he did a good job. Because Mr. Bangani did succeed in getting an eviction. eviction is very difficult because even after you get the order, people do not necessarily obey the order. So what happened is that although the order, this is now hearsay evidence, Your Worships, although the order was displayed throughout the settlement, the people continued to go and build. If I may beg leave that I can read the relevant portions of this order. It was Exhibit A when it was given. Just to explain to Your Worships how I see this order.
All along.
Thank you, Your Worships. What is important about this order of 25th November 2020 is the fact that, Your Worships, it says in the second page thereof, in paragraph 1.2, it says, the first respondent or any other person be interdicted and restrained from erecting any structures on the aforementioned land. What I do not know, Your Worships, and because at this stage, as attorneys of record, we do not have access to the docket, understanding that the law does not give us access to the docket. But we understand that both the investigating officer and the prosecutor have a duty in law and according to case law that they should put before this court all the evidence, including the evidence that actually tends to make this applicant to be awarded bail. So I do not know now if the state, including the IO, has a list of the names of these people and the time when they erected their structures. Because the first point I need to bring to the attention of the Honorable Court is that in terms of that paragraph 1.2, if these people who are now complainants in this matter, if they came in and erected structures after 2020, then it means that those people were in violation of that court order, paragraph 1.2 therefore, which says, the first respondent or any other person be interdicted and restrained from erecting any structures on the aforementioned land. So I do not know. Maybe when it is time for the state to present its case, they will clarify this for the court as to when did these people erect their structures, because there was this court order. The second thing I want to bring, I want to testify on is paragraph 1.3. It says, the first respondent is hereby ordered to demolish and remove any structures erected or placed on the aforementioned land. The first respondents, Your Worship, in this order, which is Exhibit A, is actually the illegal squatters. So these illegal squatters, who I understand are complainants, if they were there in 2020, there was a court order that said they must demolish and remove the structures. And then I think when the prosecution calls them, the prosecution will enlighten this Honorable Court as to when did they build their structures. Because either on 1.2 or 1.3, they would be falling foul of this order. And then paragraph 1.5, I am skipping Your Worship's paragraph 1.4. Paragraph 1.5 is the one that authorizes the applicant. It says, in the event the first respondent or any other person failing to remove the structures and vacate the property as ordered above, then the Sheriff of the High Court, duly assisted by members of the SA Police Services, Fleet Street Police Station, is authorized to demolish, remove any structures and evict the first respondent from the aforementioned property. That paragraph 1.5 authorizes her to evict. I have been told by people that there is an attorney here who is acting on behalf of the applicants who has said that the applicant could not demolish because that order says it must be the sheriff. I want to give this evidence, Your Worship. The sheriff, the last time I heard about demolition, her name was Nomandla Ndabeni. She comes from Ngeleni. She was our candidate attorney. I phoned her specially to assist with this demolition. Unomandla said, yo, Miss Mbanjwa, I will charge 1.6 million. I was shocked in order to do this demolition. So it became clear that Miss Ndabeni needs 1.6 million in order to effect the demolition. That is when then it became incumbent on this applicant to start doing the demolition herself. And according to me, because I asked her, I said, hey, how are you going to afford this money? 1.6 million. And you are still facing problems here with the other matters from the Zondo Commission. She said, I'm going to do it step by step. I'm going to raise money, demolish one. Raise money, demolish two. So that is how then I understood the demolition would happen. Because Ms. Ndabeni had said, I did beg Ms. Ndabeni. I can say it to her if she comes here. Why is it so expensive? Then she said, unfortunately, these TLBs, everything is expensive. So that is how then this demolition happened. When I came here, after we had trouble with the investigating officer, why I flew down from Pretoria, is to try see if I can speak softly to the people, because I came to understand that the provincial police are petty speaking. That is what Mr. Ledimo said. I don't really speak petty, but I can understand it, so I came to beg him. So when I arrived here and looked for the prosecutor, I was told that because I thought the regional control prosecutor would be the person to whom we would present this documentation so that the state has this. But the long and short of it, he said he's out of the matter. I was given a sitting lady prosecutor, Mrs. Nolusu. She also apparently became out of the matter, and then we ended with a lady I do not know. And then eventually we were told to come to this bail court. But the most important thing, which I am guided by your worships, which I do not understand to be the legal position, when I wanted to hand in evidence, which I think in terms of the law, and also in terms of the policy, because the way I understand it, the prosecutors are governed by a policy on fair prosecutions, although it's an old policy dated 2013. My understanding is if there is evidence which you think they do not have, which assists your client, you give them that evidence. I was told that no, I mustn't hand in any evidence, which is why then eventually we ended up in this bail court. But that prosecutor, I want to make the record straight, it was not Mr. Nzampa. It was that other lady who I'm said is Mrs. Nolusu. So then we ended up here. And then the difficulty I have, but that is for my learned colleague, is the fact that we were not told the basis on which the state is opposing this matter. Maybe my learned colleague as the lead attorney now understands. There is just something else, your worships, which I want to explain. And I may be using legal terminology, but I am forced to, because when this witness was cross-examined, I had a feeling that the prosecution, that is the state, does not understand how court orders work. Firstly, any court order exists in perpetuity unless it's an interim order. So therefore, when my learned colleague, the prosecutor, was saying this order of 2020 awarding the demolition was overridden by the order of Madam Justice Hartley because it was a 2024 order, he is wrong in law. He can also go research his law. That order remains valid. The order that is not valid and is incompetent, actually, and this will be argued in civil law by my learned colleague here, because this matter now has become a mix of criminal and civil law. The order that is actually incompetent and invalid, apologies, Your Worship.
Your Worship.
Apologies, Your Worship. Still under oath.
since there was an emergency, I wanted to say that they are still
Thank you, Your Worship.
anyone regarding this matter.
Thank you, Your Worship. Your Worships, I'm not being disrespectful. I'm sitting down because we are in adjournment.
No, I'm just saying I
Okay.
wanted to
Thank you. Thank you, Your Worship.
Mrs. Brandon, was still under oath.
Thank you, Your Worships. And then, Your Worship, I was still saying that. Apologies. And then, Your Worships, I was still saying that insofar as my learned colleague, the prosecutor, has said that that judgment overrides this existing judgment, he is wrong in law. That judgment, which gave the demolition order in 2020, remains valid until today. If the complainants were either at the time part of that judgment, then, and they did not stop erecting structures, first they did not demolish, then they were in contempt of that judgment. And secondly, if the complainants built after that judgment of 2020, they are still in contempt of that judgment because that judgment said they must not go build there. So in any event, there is no way they can escape that contempt. And we understand as lawyers what happens if you are in contempt of court. In actual fact, if these complainants who have laid a complaint against this applicant are part of the court orders or of the court application, which my learned colleague was cross-examining Mrs. Kwinana on, those people are not supposed to be even before court because they are in contempt of court. If you are in contempt of court, you cannot approach a court for a remedy that pertains to the matter you are in contempt of. And the reason is simple, nobody would respect the court. And it would mean that these matters are appealed via backdoor. So they cannot even be there, actually. I do not understand because I'm not the attorney dealing with this matter, and Mrs. Kwinana, through lack of funds, did not have legal representation there. If there was an attorney there or an advocate, that advocate would have said, these people cannot file even a replying affidavit because they are in contempt. And my understanding from Mrs. Kwinana is that they were told that by a Judge Zilwa, the Honorable Judge Zilwa told them that you are in contempt. Now, they are not only in contempt of a court order that they are violating. Now they have become bold and are here now in this court suing or laying a complaint against this client for malicious damage to property. I was born in Tumbu, but I don't stay here. So some of them did not know me. But I saw them. They were standing outside, a lady wearing blue, saying God is working. But they know they are in violation of this court order. let us now move on, your honorable worships. And now I come to this issue of this court order. The one my learned colleague now was reading here, saying, wasn't the applicant aware of that court order? Again, my learned colleague is wrong in law. That court order is incompetent. He can go research that. It is incompetent in the sense that you cannot have a subsequent order that is in conflict of an existing order unless that prior order had been set aside. So what is going to happen now, seeing that now this applicant is now facing criminal charges? We will then become legal representatives, and we will present this argument by form of heads of argument in court. The other thing which I want to touch on, my learned colleague has said that is the applicant aware of the fact that those people who are busy with that unlawful application in the High Court, because that is an incompetent application. These people who are busy with that incompetent application have now indicated that they are going to continue with their contempt and now bring another application for further demolition. I just want to correct, because I think my learned colleague has either read papers that have been shown to him and not been shown to me. But the papers that I have read are like this, and I think they are the correct ones in procedure. One, if there is already a matter that is before court, you cannot add into that matter by creating a new matter. You are otherwise bringing a new application. So the procedure my learned colleague was cross-examining on is incorrect. It could not be. I saw the papers, and what those people want now, they want to file a supplementary affidavit. So that notice of motion is actually, because in terms of civil procedure, you can only file only 3 sets of affidavits. Now they want to file a 4th set of affidavit, because this case that they have come here to complain about for this malicious damage to property and extortion, they are still busy with it there in the civil court, where they want that supplementary affidavit to be filed. Initially, I was not going to be involved in this matter, but I've said to this applicant, I've said, I'm going to draft papers. And in those papers, we are going to block the admission by the court of that supplementary affidavit, because these are people in contempt. They're not supposed to be before court. There's a constitutional court to that effect. They can only be before court if Mrs. Kwinana has agreed as an agent of Slipknot Investment that they should file. So what is happening in that court, with all due respect, is unlawful or incorrect. But we will argue that at the correct time. So what we are then saying then, your worships, is the fact that this order, which the client was cross-examined on, is an incompetent order. In any event, but this I leave to the to the honorable worships. In any event, the question here is, how does a person in criminal proceedings become accused of an event in civil procedure where that event is in any way incompetent? But now I want now to come to another issue which I have just marked. I'm not very far, your worships, from finalizing the things that I wanted to.
But the incompetent order challenge?
The incompetent order has been challenged in this way, your worship, in the sense that that order issues from a rule nisi. That rule nisi has not been confirmed. So what the client then did, she filed an opposing affidavit. And then the other side was supposed, after filing opposing affidavit, the other side was supposed to then close their matter and file heads of argument. They could not file heads of argument. Then this applicant drafted her own heads of argument. Then all I did, I took the heads of argument and I reworked them, because I said, the reason why I'm reworking the heads is because the heads must raise the issue of contempt, must raise the fact that what these people are doing here, they're not supposed to be before this court, and must also raise the fact that there is a competent order on the basis of which you are acting. So I said this applicant must file those heads. What I am now going to file when we leave this court, hoping that your worships will grant the bail which my learned colleague is arguing for, is to go back now and bring an application blocking the filing of that supplementary affidavit and filing a counter motion to say that matter should be dismissed and struck off the roll. So that is what we are going to be doing, your worship. And then, your worship, I know for a fact, but it will be for the lead attorney to decide. I know for a fact that there are people outside who are prepared to come and testify that actually the payment of rent, which the state interprets as extortion, was agreed upon. I'm not going to waste by giving a long testimony. Your worships have already seen the orders. All I want to say to your honorable worships is the fact that I have been included in a WhatsApp. I just don't have time to read WhatsApps. Not that I'm too busy or making money. I'm just not a cell phone person. I'm just not a cell phone person. But in that WhatsApp, there was a group that was collecting this money. So they would say so-and-so hasn't paid or so-and-so has paid, something like that. But if the court is of the view that we should download those WhatsApp, we can download those WhatsApp. They are a clear indication that the people were willing to pay and they were paying willingly. I've got them on my phone, which is there, your worships. I don't think there is anything. Colleague, is there anything you want me to say?
I think the court should be satisfied, and I am satisfied with it.
The only other thing which I just want, sorry colleague, it is very, very important that I say this point. When this applicant, your worships, wrote, when she testified here and said the charges are saying that there was conflict of interest, I must take that as my fault, because in actuality it's true what my learned colleague was saying, to say it is written as fraud. But the reason why I explained what it was is because when the prosecution, who is Mr. Mshongo there, when he put in the fraud, he built the fraud on the nature of the offense to say there was that non-disclosure. It's for that reason why we are before court on the basis of Section 83 and 84 of the CPA, saying that there is actually no criminal offense. I've already made those arguments, and Mr. Mshongo has already made his own arguments, and the judgment has been reserved in the Palm Ridge Court, because we are arguing there that actually there is no criminal offense, and the presiding magistrate there said he still wants to go through the case that we had represented, and the matter has been postponed to the 12th of April.
Thank you.
Thank you.
That's everything.
I'll give it a chance to cross-examine.
Apologies.
Yes, Your Worship. Mrs. Bandra, it's correct that you are the instructing attorney in this matter.
Yes.
Yes, ma'am. And you are also, it's your evidence that you're objecting to this interim order. What you're saying is it's invalid. That's what you're saying. Is that correct?
Okay. I don't know what is correct. You are saying I objected to the interim order.
What I'm saying is that you're saying that this interim order, that's what I just forget.
You refer to it as an exhibit.
The exhibit, yes, I believe it's exhibit B, Your Worship. Exhibit B. You are saying that it's not sound in law. Is that what you are
Yes,
saying?
that's what
Thank
I
you,
said.
ma'am. And being the instructing attorney and having been given a chance to look at exhibit B, why then did you not tell your attorney to object to the handing in?
No, we are not objecting to the exhibit. Remember, we would be killing our case.
All right.
What we are doing, we are pointing out to the Honorable Your Worships here that the state is relying on incorrect evidence. We wanted you to present that evidence. It's a good thing for us that it is before court.
All right. Okay. Yes. Let us go back to the date of the incident. You mentioned that you were with the applicant on that date. Is that correct?
If the date of the incident is
17th, the
yes,
date of
I was
the
there.
arrest. Yes, ma'am. And you were here before court when the applicant mentioned that she was not aware that it was the police who were entering the premises.
Yes, remember, she said she was not aware that it was the police. Maybe I don't know what she thought of, but the truth of the matter, normally the arresting police are ordinary people like this gentleman. They don't come with these hoods, you know, and what are these things? And rifles. You see, maybe that is what confused him.
So
and I also asked the police, why are they so heavily armed? You know what they said? They said the police who went there are actually a special attack force, because they were told that this client is dangerous.
Okay. So on the day of the incident, did you observe any whether the vehicles that were there, were they marked vehicles or were they not marked vehicles?
Listen, sir, they were police vehicles. I can point out the police. You see, that's why we allowed it. That's why I said, go, Mrs. Kwinana, because they are the police. There was a colored gentleman with gold teeth. He opened his thing and said, I'm a warrant officer. to say here is a sign and a warrant officer, but he didn't give us what was important, that is that J50 thing.
Yes, I'm just asking, reason being, your client mentioned that, oh, yes, the client mentioned that she had no idea.
Your Worship, I think this question is directed to the wrong person. That the client answered for herself, and not for this witness to answer for the client.
Thank you for it.
Reason why, Your Worship, the state asked this question is that if the cars were marked vehicles and the police were uniformed police, why then would she say in her testimony that she didn't know they were police?
Again,
It's for her to ask.
For arguments, yes, Your Worship. We'll just reserve that for arguments. I just
and
wanted
also,
that.
Your Worship, that was answered. That my client was afraid and she was in a state of shock. She was not aware who these people are. Because the people who were to arrive in her house were the people to take the statement.
It was a state of mind.
Yes, Your Worship.
To be honest, colleague, I almost cried. It's just that I didn't want to cry because I'm an attorney and I'm older than the applicant. Otherwise, I was so shocked.
No further questions, Your Worship.
Any other reason?
None whatsoever, Your Worship.
Thank you.
Thank you, Lord.
Your Worship, just one witness for us, Miss Mbidi. I think she is outside.
The full answer?
Mnongosazana Mpapa.
Do you have any objection to it?
Ndizawucela uNtozana Ntonto.
Akho nto ime phambi kwakho sesingayithetha inyaniso phantsi kwefungo senkundla.
Ayikho nto.
No objection, Your Worship.
You swear that the evidence you shall give is the truth, the whole truth and nothing but the truth if the list of the days of life in 600.
Uyafuna umnqondo uzomnika phi ukuba inyaniso epheleleyo. Ukuba kunjalo, uphakamisa isandla sakho sokunene, sincede ukuzithetha inyaniso.
Ndincede Nkosi ndithethe inyaniso.
Mrs. in Your Worship.
Taking to account my blood.
Yes, Your Worship, I will be very quick with this witness. Ma'am, I understand that you are also called Miss Mbidi. Are you Miss Mbidi?
Yes, it's my maiden surname.
Yes, that is my maiden surname.
Yes. Miss Mbidi, where do you stay? Or Miss, what is the saying that you are shouting?
Uthi ngubani kanekufana yakho?
Mpapa.
Mphafa.
Miss Mpapa, where do you stay?
Uhlala phi wena nkosikazi Mphafa?
Ndihlala eRockville kufarm 9 25.
I live at Rockville, Farm 925.
And do you know the applicant is before court?
Uyamazi umceli ibheyili nolapha enkundleni namhlanje?
Ndiyamazi ngoku kodwa bendingamazi ufika kwam.
Yes, I know her now, but I didn't know her when I arrived.
Explain just that part.
Naba nje kuloo ndawo ke ngoku,
When you arrived, you did not know, you know her now.
uthi kaloku ngoku kufika ungekamazi kodwa uyamazi ngoku.
Ndifike ngoDisemba nge-2nd kaDisemba ngo-2019. Ndifika kumhlaba ekuthiwa ngumhlaba kaThixo bagece ihlathi.
I arrived in December 2019. When I arrived there, I was told that it was the soil of God. The area was cleared.
Yes, proceed.
Zifikile impepha zokuqala zifika ndikhona. Kulapho ndibonileyo khona uba umhlaba unomnini.
And then the first documents arrived. It is when I realized that this soil has got an owner.
Yes.
Zithi impepha wena usele uphakathi phuma wena ungekangeni suba sangena.
These papers were stipulating that you that is already in, you must move out, and the person that has not yet moved in must stay out.
Sinabantu ke besibabiza ngoba zikomiti sizithathile impepha zethu sazihandlisha kubo.
We've got these people whom we call our committees. We took the documents to them.
Yes.
Bathe bona ewe umhlaba unomnini. Kodwa ke salani yakhani ikritshi yakhani nezikolo uzawunithethelela urhulumente nokhe nibe baninzi apha.
And then when they returned, they answered by saying, we must stay. And we must build creches, we must build schools, and the government will speak up for us.
You were also encouraged to multiply.
Nechukuti yakhani nigcwale kugcwaliswe indawo.
Ewe.
Yes.
Proceed.
Kodwa ke
Who must have said those?
Kubani lo uthetha loo nto emazi igama lakhe omnye wabo okanye ziikomiti bezithetha ngexesha elinye bo?
no ukhona umama wayesiphethe kwakusithiwa ngumama uDora kodwa ke iikomiti zazithetha namxhelo.
What happened there, the spokesperson there was Mrs. Dora, but the committees were agreeing to what she was also saying.
All right. Yes, proceed.
Kuba,
Liqhubekile ke ixesha watsho esithi uba sike sanexesha elide noko akuzuba lula ukuphuma.
and then it was also stated that if we are staying there for a long period, it will not be easy for us to be removed.
To cut matters short. Umama uKwinana ufikile okokuqala.
Mrs. Kwinana came at some stage on the first occasion.
And you met her.
Wahlangana naye.
Yes.
Yes.
Wathetha nathi umama uKwinana kodwa ke singabanye saba stubborn kuba sasinela themba loba siza kwakhelwa izindlu.
Well, Mrs. Kwinana spoke to us, and because we were stubborn, thinking that houses should be built for us.
Now,
Umama
just at that point, ma'am, how did she speak to you? Did she speak to you as individuals or did she call the community?
Ebethetha nani mntu ngamnye ngexesha lakhe okanye ubize abahlali uba mabasondele bazomamela uba uthini na?
Umama uKwinana ubize abahlali wazazisa engazange alwe nathi.
She called the community, introduced herself, not fighting with us.
Approximately how many, I would say, members of the community in that space?
Awuthekelela mhlambe bebenoba ngaphi abahlali bebephayana ke ngoku ngalamini
No, generally in that space.
Okay,
piece of land.
masithi ke ngoku kulaa ngingqi ngela xesha bebesebengaphi abantu ababehlala phayana kakade.
Bese sifikile phaa ku-8.
We were around 80 people.
Would you also confirm that a major number to 80 must have attended?
Ukuthi ungavuma ukuthi phaa kwi-80 abantu mhlambe bebesebekhona abantu abebezile entlanganisweni okanye noko abantu abaninzi abafike kwi-80 okanye nje ngaphantsi ko-80 kancinci.
Bebesebezile entlanganisweni sebewuvile nomhlaba uba ithini into yabo.
They had attended the meeting before and they had already heard who this land belonged to.
To the gist of the meeting, what transpired there?
Okay, izaphe kugcwele ke ngoku entlangano uba kwenzeka ntoni na phayana.
Entlanganisweni umama uKwinana uzamile ukusibonisa wathi wabe usinika nehistory yomhlaba esasingayazi singabanye abantu.
In this meeting, Mrs. Kwinana tried to explain to us, even explaining to us
What did she say?
wathini kanye kanye amazwi awasebenzisayo.
Umama uKwinana wasixelela into yoba i-eviction siyifumene, i-court order siyifumene. Kodwa
She told
ke
us that we had received an eviction and a court order, but
kodwa ke sacela thina singabanye uba siyacela Mama Kwinana kule meko sikuyo singenayo nendawo uhlala ayikho na enye indlela esinokwenza ngayo.
Well, and when we requested her, Mrs. Kwinana, is there maybe any other alternative you can come up with in this problem that we do not have any shelters or place to stay in?
Satsho sicela ukuba singakwazi na uyawunkqonkqoza kwamasipala sifike sibeke le ndaba simcela naye asincedise ngoba nguye umntu at least onokwazi ukuthetha uba aba bantu bahleli kule ndawo sibe nathi sisithi singaba bantu bahleli kule ndawo asinayo indawo.
We requested her if we could approach the municipality so that she can also agree and tell the municipality, here are these people, they need a place to stay, they do not have alternative place to stay.
And what was the mood during this deliberation?
Isimo sinjani ngoku kulo lonke ke ngoku elibhunga lenu phayana?
Isimo ngoku okanye ngoko
Ngalamini kaloku nisentlanganisweni nimcela nidomboza apha kuyo.
isimo sasirayithi ngelaa xesha.
No, the mood was good at that stage.
Yes, proceed.
Kodwa ke isimo sirayithi uMama Kwinana sekufuneke enabo abantu abamjongileyo nabamkhuselayo uzukhumbule ibingesithi sonke ebebethetha le nto.
Well, the mood was also in that fashion that Mrs. Kwinana had also had to bring along some people that could protect her because all of us were speaking in one language according to this situation.
But would you say the majority of the people were actually in consent or in agreement with Ms. Kwinana?
Kodwa ke ungathi ubuninzi babantu ke ngoku bonke bebethetha le nto ithethwa nguMrs. Kwinana na?
Ewe kangangento ba sino-WhatsApp sibaninzi phaa unoba ngabantu nje abayi-18 abangekhoyo phaa. Sesinegrupu naye ngoku.
Yes, we also had a WhatsApp group. I think there's about 8 people only that are not on the WhatsApp group, and she's also part of the WhatsApp group.
And what is this WhatsApp group for, man?
Ithetha ukuthini ke ngokule group yenu ye-WhatsApp? Ayokuthini?
Kulapho sikwaziyo uncokola. Siyile kwamasipala.
We did go to municipality.
Safike sacela noMama Kwinana asincedise ekuyeni kwamasipala.
We approached municipality asking Mrs. Kwinana to also assist us in going to the municipality.
Kulapho kuvele khona ke into yoba uMama uKwinana uya-owa umcimbi we-rates. That is umbane namanzi esiwusebenzisayo.
That is when it came out that Mrs. Kwinana is behind the rates, electricity and water.
Lo WhatsApp ke injongo yakhe yoba singakhawulelana njani nezi rates ngoba zenziwa sithi azenziwa nguMama Kwinana.
And she then requested and asked, how can we assist in getting these rates up to date? Because we are using this electricity, we are using this water. How can we assist her in having it paid?
Saba nesivumelwano sokuba singazikhupha i-1,000 rands. Kodwa wabanayo imfobe kuba abantu abafani, kukho abantu abangenanto at all. Kukho nabantu abangazange bayikhupha. Sorry.
We came to an agreement of paying 1,000 rand each. She also showed mercy by acknowledging the fact that there were people that were not money-wise or didn't have money, so that she can also assist them.
All right.
Yonke ke lonto ye-1,000 rands nabakwaziyo ukuthetha naye bathi asikwazi ukufikeleleka siyiqale ngo-August.
Even this 1,000 rand issue, and these people that said they cannot come up with that amount, we started it in August.
And all this that you're talking about is also in the WhatsApp groups.
So, okay. Zonke ezi zinto ziyavela ke ngoku ku-WhatsApp.
Ziyavela kodwa ke siyakwazi nokuthetha naye uMama uKwinana ngoku. Akasenalo olaloyiko loba mhlawumbi angeza exhagiwe ngoba besesiyifeni.
Yes, it does appear on the WhatsApp, and we can even speak to her individually, and she no longer has the fear for her to be brought by a security personnel or people that can come and protect her. Yes, we even became family.
Can you repeat that?
Phinda,
umama uKwinana besesihlala naye ngoku
you were already staying with Mrs. Kwinana,
ngaphandle kukaWhatsApp.
even without WhatsApp.
Now you mean if there's someone alleging that they were extorted in the area in which you stay, that is false.
Uba unothi umuntu apha athi yena ebenzikivwa ke ngoku kulaa ngingqi ungayibona ibubuvuvu oko.
Mhlawumbi angatsho yena kodwa mna ndiyibona ibubuvuvu.
Well, that person might say that, but I myself say that is false.
Your Worship, I may not have any further questions to this witness. That's her evidence.
See the time now is almost 1, it's time for lunch. And Mrs. Buff, the court will adjourn now until 2. Not allowed to talk to anyone during the adjournment regarding this point.
Nkosikazi awuzukwazi ukuthetha nophi na umuntu malunga neli tyala ke ngoku sizawuthatha ngomama isidlo sesemini uyakwayo kwethu soqhubeke ukwazi uba uzopheka usophulwa ngemibuzo ne.
Right, court.
Bakutheni izinto zenu zidiliza nje?
No. All I asked was, did you speak to them after they had their houses demolished?
Uke wancokola nabo na emveni uba izindlu zabo sezidiliziwe na?
Khange ngibabone.
Never spoke to them. Azange uphinde babone. I haven't seen them again.
Okay. And according to you, I know that you said that you never spoken to them, but do you think they were happy that they had their houses demolished?
Ngokunokubona kwakho ke ngoku ewe ndithe ndiyavuma uthi zange uphinde babone emveni koko ucinga uba ibibonwabisa laa nto yoba mabadilisele izindlu zabo na?
Andiqondi uba iyabonwabisa.
I don't think they were happy at all.
No further questions, Your Worship.
None whatsoever, Your Worship. And at this juncture, the defense closed its case for the applicant.
Very much.
Your Worship, the state is intending on calling Mr. Ledimo, Your Worship, who had been mentioned in the leading of evidence in the defense's case, Your Worship. However, Your Worship, he is before court. The state has not had ample time to actually consult with Mr. Ledimo, Your Worship, as the state did not know that we would need to call him, as the testimony given by the defense implicated him, Your Worship. The state is therefore asking. The time now is 2:15, Your Worship. And this is not the only witness that the state is intending on calling.
Do you intend to start with him?
We do, Your Worship. We do. As to his testimony is pivotal in the sense that he will give us exactly how the arrest happened and what had transpired when the applicant before court was brought to East London, the whole process, Your Worship.
Because they really have us to.
No. The state is asking at least for an hour and 30 minutes.
Your Worship, we are objecting to that. In that now the state is playing a dilly-dally. This is someone's life, and the liberty of such a person who is in custody, Your Worship, is very important. The state knew of its witnesses. One of the witnesses, Your Worship, who was said to be a witness in this matter, is before court, sitting next to my learned friend. The state now intends not to call that person. We left here, Your Worship. I know the deliberations that we had were that the state is more, Your Worship, inclined to grant bail when we come back. It can then not be that today, Your Worship, you are being told that the witnesses of the state are still to be consulted. It's unfair, it's unjust, and Your Worship, we know that it is the buying of time by the state. Our house is in order, Your Worship. We need to proceed with this matter and finalize.
May I first address the fact that the defense is mentioning that the state was inclined to grant bail. Conversations that were had in the passage, Your Worship, are conversations that were had in the passage. I had indicated to my learned friend the fact that upon consultation with the investigating officer and her verifying a number of outstanding issues, which the state had said on record as to why we were asking for the postponement in any event, it has now come to light, Your Worship, that we are opposing bail. And due to the fact that Mr. Ledimo was implicated,
Were you not aware that he was going to be?
was not, Your Worship. I was not aware in any way.
I cannot give an adjournment more than continuance.
Then may the matter be rolled over to tomorrow then, Your Worship.
No, Your Worship. No, Your Worship. We object again to that. Your Worship, if the basis of the state's case to object on this matter is that which they have, they need to present it here. If Mr. Ledimo was not part of the basis for them to object, to oppose to this application, they cannot just put him now. We knew who our witnesses were. We brought them before court as their ducks on the line. Now we cannot expect, Your Worship. We cannot now expect, and Your Worship will plead with this honorable court for its mercies and a just view of what is happening before this court. This is, Your Worship, someone's life is at stake. And someone's life, someone's health, Your Worship, is at stake. We have brought all that we have brought before this court, knowing that the state will probably be playing these cards before us. We object to a further apportionment.
Let's just go to the relevance of Mr. Ledimo's evidence as far as Section 64 is concerned. How relevant is the evidence?
He will be
to say that she will comment on the question of an arrest.
Yes, Your Worship. He will speak on the aspect of the fact that the applicant before court is a flight risk, Your Worship, which is the primary consideration in all bail applications. The fact that will the applicant stand trial. And as such, Your Worship, may we also remember the fact that this matter only appeared in our court on Tuesday. I believe on Monday, Your Worship. And we had asked for a postponement, like I had said, to verify a few issues. It is now Wednesday, Your Worship, where the matter is being heard. The state is just asking for an indulgence to roll the matter over tomorrow. We will be ready, Your Worship, to finalize the matter tomorrow.
I will comment on
Okay, thank you, Your Worship. Your Worship, the issue now, it's clear that my learned friend is aware of the issue in which Mr. Ledimo will have to come and testify about. That it is an issue of whether my client is a flight risk or not. Why not call Mr. Ledimo and testify on the aspect of the flight risk of my client? My client, he has now submitted before this court that my client will be testified on by Mr. Ledimo on the aspect of being a flight risk. Therefore, there is no need for consultation. We have granted ample time to the state to do whatever that they need to do. It cannot be that an older person can be kept like this, and the wheels of justice, Your Worship, must be seen to be turning.
I will only
May I reply, Your Worship? Just one reply, Your Worship. Your Worship, I do hear the submissions of my learned friend, Your Worship. However, the state is strongly opposed as to how we should be told to present our case. Firstly, we will not be told as to the fact that we do not need to consult. We may just put him on the stand. That is not how we are going to proceed, Your Worship. Those are the submissions of the state.
I understand that the state cannot be told how to conduct their affairs. However, it is also important for the state to take into account the fact that it must be relevant evidence that will be laid here. And that I am not going to roll over this matter to tomorrow, as the state has already requested a remand and they cannot grant another one today. The right to liberty is one of the most important rights that the court has to safeguard. Therefore, I am prepared to allow the state to consult with Mr. Ledimo for at least 30 minutes, and thereafter we proceed with the relevant evidence.
May the state just put on record, Your Worship, that if the state is not in a position to proceed, Your Worship, we shall let this court know that we are not in a position to proceed, Your Worship. This court pleases.
All eyes,
Parliament.
Yes.